Just I will be here. You tell me what time I have to start.
Sure, sir. Sure, sir.
Okay. Okay.
Good morning, everyone. It is indeed a privilege to welcome you all to the one-week faculty development program on innovations and intellectual property in civil engineering research, organized by Department of Civil Engineering, Sir M. Visvesvaraya Institute of Technology, Bangalore. Innovation is the key to progress, and intellectual property safeguards that innovation. In civil engineering research, both play a crucial role in shaping sustainable and advanced solutions. This FDP is designed to enlighten us on the latest advancements, research methodologies, and intellectual property rights in the field of civil engineering. A great event is marked by great speakers, and today we are honored to have with us Mr. Uday Shankar, Deputy Controller of Patents and Designs, Patent Office, Chennai. To give a brief introduction about our distinguished speaker, I now invite Dr. Shivanna S., Associate Professor, Department of Civil Engineering.
Good morning to one and all. I, Dr. Shivanna S., Associate Professor, Department of Civil Engineering, deem it as a honor and a privilege to introduce today's speaker, Shri S. Uday Shankar, for the one-week faculty development program on innovations and intellectual property in civil engineering, organized by Department of Civil Engineering, SRNVIT. Shri Uday Shankar has completed his bachelor degree in mechanical engineering and master's degree in refrigeration and air conditioning. Presently, he is working as Deputy Controller of Patents and Designs, Patents Office, Chennai. He has so far conducted more than 45 awareness programs at various colleges and universities on patents and intellectual property rights. He has also visited Japan and attended a program on examination procedures at Japan Patent Office. Sri Uday Shankar is an expert in IPR process, and I am sure all the participants will benefit to a large extent from his lecture. Thank you. Over to you, sir.
Hello.
Hello.
Good morning, madam.
Good morning, sir.
Good morning, everybody. Since it is an online session, there won't be any interaction between us. So then and there, you please ask some questions or tell me that you are there. Okay. So I am directly going into the subject, intellectual property rights. Actually, intellectual property rights is basically a system to protect your ideas, a system which is used to protect your innovative ideas. Actually, intellectual property means simply simply defining, it is a system to protect your ideas. Okay. Why we need a system to protect your ideas? For example, suppose I am purchasing a land. After some times, I came to know that somebody has encroached that land and somebody has constructed the building without my permission. So what is the legal remedy I have? The only legal remedy I have is I have to go to the police station or I have to go to the court. So when I approach the court or police station, they will ask for the evidence. I have to show that this is my land. So some evidence I needed. So what evidence I will have? I have a document in my name showing the area of the land, address of the land, every details will be in the document and the document is written in my name. So that is the only evidence I have to show that, to prove that I am the owner for this property. Another example, if somebody has stolen my bike, What is the legal remedy? I have to approach the police. I have to go to the court. So there also they will ask for the evidence. What evidence I have to show that I am the owner for this bike? RC book. My name is in the RC book, and the number of this number, make, color, every details of the property will be included in the RC book, and it is in my name. So it is very clear, and it is very easy for me to prove the ownership for the property. These are all one type of property called as tangible properties, because we can see, we can touch. These are all tangible in nature. Another type of property is there, intangible in nature, that is your ideas. Your ideas is inside your mind. Nobody can see your idea unless you are expressed, unless you are disclosing your idea to the public. Nobody will know that you have this type of idea. So such a peculiar property is your idea, your innovative idea. The problem is when I am disclosing my ideas to the public, if I come to know that somebody has misusing my idea or somebody has infringing my idea, what is the legal remedy I have? In case of land, in case of bike, in case of car, in case of my house, I am having evidence to prove my ownership. But in this type, when I'm disclosing my idea, when I come to know that somebody is misusing my ideas, what evidence I have? So I need some evidence or proof to show that this is my idea. I am the owner for this innovative idea. There comes the importance of this intellectual property rights. So now I think you are clear that this intellectual property rights gives protection to your ideas. The same way the documents giving protection to your property in case of house, in case of idea, this intellectual property gives a protection by giving a evidence to show that I am the owner for this idea. This is a simple explanation for this intellectual property rights. Okay. Now we are coming into another domain, innovation. So what is meant by innovation? Innovation is the basic or essence for any development in any field. It's a basic factor. Without innovation, there won't be any development. If you see our ancient period from this, we compare the ancient period to this time, there have lot of improvements, lot of changes have taken place because of this innovation idea, because of this innovation, because of these innovative ideas by someone. So the definition for innovation is, we should understand the definition for innovation in a clear manner. So what is meant by invention, innovation? Another thing is that what is meant by invention. First we see what is meant by innovation. So innovation means improving. Simply telling, innovation means improving, reinventing and redefining. That means I am not telling to innovate something extraordinary. I am telling innovation means improving. Improving means improving from already existing one. Something is already existing there. You are improving that one. That is called as innovation. And invention is already there. You are reinventing. Already invention is there. Something is there. You are reinventing. Already something is defined. You are redefining. So everything is already existing and you are putting some effort. You are adding some effort on the existing one and you are improving that. This is the existing one. You are adding one more idea on the existing one. That is called as innovation. So innovation is very simple. You no need to search for from the beginning. You have to see the existing one and what improvement that existing one needed. If you are giving some improvement, that means it is an innovation. That idea is called as innovative idea. This is an actual definition. And another terminology which is called as invention. So what is meant by invention? It is invention. Innovation is in a broader sense in any field. Invention means little bit narrow down. I am narrow down it. Invention is purely depends related to in the field of science and technology. Innovation is in any field. Invention is very narrow and it is purely related to in the field of science and technology. So what is the definition for invention? Invention means a solution for a technical problem. There is a technical problem and you are offering a solution for that technical problem. That solution is called as invention. Problem is not called as an invention. Solution is called as an invention. So in any field, any field means in the field of science and technology. It may be physics, it may be chemistry, it may be biology, it may be engineering, it may be civil, mechanical, whatever it may be. there is a technical problem and you are offering a solution for the technical problem, that is called as an invention. Okay, clear? Madam, I am audible.
Yes,
Hello?
sir. Yes, sir. Yes.
My screen?
Yes, sir. You're audible, sir.
So in order to understand the concept of invention, I am giving this example. So this is a two-wheeler. This two-wheeler having many parts having. I am taking one example as a side stand. The two-wheeler having two types of stand. One is center stand, another one is side stand. So I am taking side stand. Now my doubt is, what are all the problems you might face when using the side stand? Everybody using the two-wheeler. This is one type of two-wheeler and this is one type of two-wheeler. And when we are using the side stand, what type of problem you will get? Each people will get different types of problem. But I am telling that one of the main problem in using the side stand is often we'll forget to take it back. It will lead to accident. There will be a speed breaker. There will be some uneven path in the road. So when you are not taking the side stand, the chances for accident. So most of the people will forget to take the side stand when they are using it. Center stand means there is no problem because without removing that you can't move the vehicle. So that is the one thing. But putting the center stand is always a difficult task in the uneven surface. So most of the people we are using the side stand. So when you are using the side stand, we forget to take back the side stand. So it will lead to accident. Okay, this is a simple diagram for the side stand. See, everybody know about this one. So this is a technical problem actually. This is not a social problem. This is a technical problem because it's a device. This is a bike we are calling in a generic name, but it is a device used for movement. So in this device having various parts, one of the parts is a side stand, and side stand having a problem, which is the user will forget to take the side stand, and this is a technical problem. Okay. So what type of solution you can offer for this technical problem? There will be many solutions you can offer, and some of the basic solution we can offer is, first instance, a light indicating mechanism has been invented to solve this problem. A light indicating mechanism. That means a blinking light will be provided nearby the speedometer, and when you are not taking the stand back, it will blink. Correct. So there is a problem, and this blinking is a light indicating mechanism is the solution. So problem and solution. This is called as an invention. You are identifying a problem in a particular field and you are offering a solution. So without taking the side stand, the blinking, that light will blink continuously. It will be the indication for you saying that you have to remove the side stand. So that is a problem and this is a solution. Yeah. So this is a solution number one. And solution number two is, I am offering a sound making mechanism. Now previously it was light indicating mechanism, now sound making mechanism. It is also I am providing a sound making mechanism nearby the speedometer. So when I am not taking the side stand, it automatically make a sound. So this is another solution for the same problem. So that is light indication mechanism is a first solution, that is called as an invention, and sound making mechanism is a second solution. This is also called as invention. And third one, again I am improving. Now I am improving with, if you are not taking the side stand, the engine will not start. That is another mechanism. So this is also called as an invention. And fourth one, when you are not taking the side stand, you cannot put the gear stopping mechanism. Clear? And solution number one is A, solution number two is B, solution number three is C, and 4 is D. For example, side stand with light indicator is a solution number one, called as an invention. Side stand with the sound arrangement is solution number 2. This is also called as an invention. Side stand with the gear stopper. That means you cannot put the gear when you are not taking the side stand in the closed position. And engine will not start arrangement is another solution. The concept is, for a single problem, so far you have offered four types of solutions. And this is not the end. You can give fifth solution, sixth, seventh, eighth, n number of solution you can give. But the problem is a single problem. This is the way inventions are happening. It does not mean one problem should have one solution, and one problem identify one person and he became an inventor. It is not like that. For a single problem, I can invent a light mechanism, you can invent a sound arrangement, and somebody can go for gear stopper, and somebody can go for engine will not start, and somebody will. There is no end for that. But the problem is same. For the same problem, any person, any number of solutions depends upon their own capacity, depends upon their own innovative ideas. They can offer a solution. And when you are addressing a problem with a solution, that solution is called as an invention, and the person who gave that solution is called as an inventor. That's all. It's very simple. Invention means not only an improvement, it's a improvement. I am telling that in a broader sense, that is innovation. In a narrow down sense, in the field of science and technology, we are calling as invention. Invention means finding or offering a solution for a technical problem. And if you are offered a solution, you will be called as an inventor, because that solution is called as an invention. Clear? This is a simple idea about invention. So who can do the invention? Anybody can do the invention. Who have the capacity or who have the knowledge to find out the problem in a particular field, in your field, and when you are offering a solution, that is called as an invention. So this is the way invention is happening throughout the world. This is not only in India. Throughout the world, wherever you go, invention means there will be a problem and somebody is involved in finding a solution to that problem, and they came out with the solution, and that solution is called as an invention. And the people and the person or many persons involved in finding out the solution is called as inventor or inventors. Clear? So any number of people can combine to offer a solution. Does not mean that a single person should involve. Any number of person can involve in offer a solution, and each one is called as an inventors, and a group of people is called as inventors. Correct? So 4 person A, B, C, D has given 4 types of solution for the same problem. Okay. Next one is innovation or invention, whatever may be. Since it is a civil engineering, we concentrate on invention. So you are clear that invention means finding a solution to a technical problem. Okay. So how this invention will form in the first sense? A concept, a formation of concept or idea in the mind. First, it will be created in the mind. You are seeing the problem, you are addressing the problem, and you are thinking about the problem, and you are offering a solution in the mind. Formation of concept or idea in the mind. This is the first step of invention. And the second step is documentation. That means you are writing in the documental form. Correct? That is thesis. And third one is a publication. And you are publishing your concept, your idea to the general public. So this is the 3 steps actually happening in any field of innovation or invention, whatever may be. Formation of concept or idea in the mind, then documentation and publication. Up to this, there won't be any problem. But if you come to know after this process, somebody is misusing your idea, somebody is copying your idea, somebody is making use of idea for a monetary benefit without your consent. So you have invested your idea, you have invested your labor, time, money, everything you have invested to come out with the solution, to come out with the invention. But without anything, somebody is, by reading your documentation, because you are publishing it, once it's published, it is going to the public domain, so anybody can read. So somebody is reading your document and they are misusing that. Misusing means they are using in a good sense only, but without your knowledge, means it is another form of misuse. Without your consent, they are making money out of your idea, and you will be the loser. So what is the legal remedy you have? Initially, we are speaking about the legal remedy. In case of land, you have a document, but in case of idea, there is no document. This documentation is written by you. In case of land, The document is given not by you, it is prepared by someone and it is acknowledged by the statutory body, that is a government, state government. When I am purchasing a land or when I am purchasing the house, I am registering it in a registration office. That is not a private body, it is a statutory body. That means it is a government body. Government body has to sanction it, has to declare it that you are the owner for that property. But here, your idea, you are creating a document and you are publishing. The document is created by you, but it is not acknowledged by any statutory body. It is not acknowledged by any authority. You are creating your document. So this document should not confuse with that document. This document is created by you and it has no legal value. When you go to the court, suppose you are creating an idea, you are documentation it and you are publishing. I am copying that idea. I am making use of that idea in the market, and that I am getting money. You are going to the court. The court will ask for the evidence. What evidence you have? You will show this document. This document is not evident because this is not authorized by the statutory body. So there is no proof. And I will claim that this is my document and this is my idea. You claim that this is your document, this is idea. How the court will decide? The court will not decide. They can't decide. So who is producing the pakka evidence? They only win the case. So out of these three, there is one more step you have to follow that is very, very important, very, very crucial, especially in this present time. This is very, very important for the another one more step, that is protection. You see, I am rewording. I am arranging this. Formation of concept or idea, documentation, publication, 1, 2, 3. Now I am inserting one more thing, protection. Protection than publication. Formation of idea, documentation, protection than publication. So protection means how to protect. There comes the importance of intellectual property rights. So intellectual property rights is a system. I told in the first instance, intellectual property rights is a system because the system having various tools. Why the system having various tools? Because all the innovations are not similar. One person will do innovation in science and technology. One person have innovative idea in the field of arts. One person having innovative idea in music. One person have innovative idea in photography. So innovation means ideas are not similar. So one tool is not enough to protect everything. So we need a different tool to protect different types of ideas. So intellectual property having different types of idea. For example, patents is there. It is one tool. Designs is there. Trademark is there. Copyright is there. This is the generally four types of tools we have in the system. So each tool is different in their own nature, and each tool is used to protect different types of ideas. Okay, that we'll see one by one. So IPR tools. So I am telling this as a tools because with the one tool you cannot repair entire problem. Suppose you are having a problem in one particular device. You are using screwdriver. The screwdriver cannot be used for another purpose. Screwdriver has its own purpose, and spanner having its own purpose. You cannot use a screwdriver to repair the entire system, entire device. So in the same way, our ideas are not similar. We have different types of ideas. So we have patents, design, trademark, copyright, and geographic indication. Different types of tools we have. Okay, just briefly one by one we'll see. So I am concentrating especially on patents because I think this is a gathering of civil engineering. So I am concentrating only on patents, but just for understanding, I will talk about design, trademark, and other thing. Okay. So what is patent? You just read it. What is patent? Madam, this is clear. The screen is clear. Madam? Hello?
Hello, sir.
Madam, the screen is clear.
Yes, sir. Yes, sir. It's very clear.
I'm audible.
Yes, sir. You are audible.
If you have any problem, you just tell me, madam, because I'm sitting in front of computer and talking.
Yes, sir. I understand. We'll inform you, sir.
So patents is one type of tool which is used to protect your invention. I'm going very specific. Invention. Patent is an exclusive right granted in for an invention. The invention may be a product or process. It should offer a technical solution for a technical problem. That is the meaning of the patent. The patent is an exclusive right granted. So patent is a document, certificate. We are giving a certificate saying that he or she is the owner for this invention by a statutory body, by a central government. Again, I'm telling this patent is granted to you by a statutory body. That means a government of India. No private body can authorize or no private body can give this exclusive right for your invention. Only the government of India has the rights to give this patent. And this is a territorial rights. That means you are applying a patent in India. That you are getting patent means that patent is valid only in India. You cannot exercise the power in other countries. If you want to do business in other countries, or if you want to protect your invention in other countries, you have to apply for other countries also. Some route is there. Generally, I'm telling you have to apply in other countries also. Since it is a territorial rights, we have the rights only in India. And the right is for 20 years. After 20 years, it will go to the general public. So 20 years is too much for any invention to become obsolete. After 20 years, it will become old, or people will not use your invention in a big manner. So they are offering a 20 years period for your protection. So in a simple way, patent is an exclusive right granted for the inventor for his invention. Invention means a solution for a technical problem, and it is a territorial rights and the period of 20 years. Clear? So this is the definition for patents. You see this diagram. This is an yearly 2000 and yearly, for example, 2023. You see the difference. Both the purpose of both the device are same, but you see the changes. Each changes is happened in a different period of time. The first yearly 2000, for example, that year is just for understanding purpose I'm putting 2000, maybe old also. You see the arrangement, and you see the problem. What are the problem you'll face by using this old one? And they are going for one type of improvement. After sometimes again they need some improvement. They are going for next type, and this improvement is keep on going. And at the year of 2023, we came with this arrangement. You cannot see anything. There is no need to take that heavy stone out. Cleaning is easy. Everything is completely packed, and weight also very less. So this is called as invention. And each and every improvement is solving one problem. Because you are solving one problem, each and every improvement is called as an invention. And the person who is giving that solution is called as an inventor. The next step or next year, they are coming with an improvement. One invention. Next step, next improvement, another type of invention. And does not mean that a single person should do all the improvement. The improvement can be done by one company, and the same problem addressed by another company. Each company will give different types of solution, different types of model, or different types of improvement. And finally, the end result will be an improved version which is available in the market. Does not mean a single company involves in creating this type of improvement. Many companies are there. They are having their own R&D. They are involved in developing new concepts, new ideas to attract the customer by solving some of the problem. Okay. So before going into this one, I would like to tell you an example. Can you see this one? Because I think it is related to civil. I took this example.
Yes, sir, it's visible. We can see it.
What is any difference you can see this? You have to tell.
Bamboo reinforced column.
bamboo reinforced column by replacing the.
Steel reinforcement bar.
So they are replacing the steel with the bamboo, because by using the steel they are finding some problem. And this is an innovative approach, innovative idea. Instead of steel, they are using a bamboo. But I don't know which one will be stronger than, which one is stronger, bamboo or steel. But they are using. You see, they are completely replacing the steel rod with bamboo sticks, because in this area bamboo is available in a large manner. So instead of steel, they are replacing the bamboo like this. So you are expert in that. I am just showing with as an example. A complete replacement. Yeah. Now it is reaching the end. There is no steel I can find. This concept you know already, madam? See, the reason, what is the reason for using the bamboo instead of steel? A tensile load application result shows by bamboo are exciting because the ratio of tensile strength to the specific weight of the bamboo 6 times greater than steel. So this is the reason they are saying that by using the bamboo instead of steel. This is an innovative idea. Okay. I don't know whether they applied for a patent or got patent. This I got from in the public social media. Okay. But by seeing this, a person, I think he's from Arabian country. There the dates. See, one person is got an idea from this bamboo, and he is living in Saudi country, I think so, where you can get plenty of date palm trees. So he is replacing entirely the steel structure with this date palm tree, and he's decided to apply for a patent. So how he is applying for a patent? Before seeing the claim part, you just see this diagrams. See, he is replacing this steel rod with date palm branches. Completely the same thing is happening here also. Instead of bamboo, he is replacing with this one. So how he is doing? Date palm branches bark preparation specific to the requirement. Before that, seasoning of DRP bars. Seasoning of DRP bar. Next step, experimental study, casting of RC beam, testing of RC beam, result comparison. This is the experiment. This is an R&D work done by that person. So after doing this one, he decided to apply for a patent. That bamboo, I don't know whether they applied for a patent, but this person is applied for a patent because he thought that this is an innovative idea by replacing the steel rod with date palm branches. So he want to protect his idea. So he applied for a patent. Okay. So how he is applying? This is the claim part. How he is claiming in the patent office. If you read this, you can easily understand how he is claiming. You see the claim number 1. A reinforced concrete beam cast comprises a date palm tree ratchets bar, a glass fiber reinforced polymer. This is the actual innovative idea. Rowing composite characterized in that the DRB bar are coated with the said GFRP woven rowing to increase the flexible strength of the reinforced concrete. By doing some research, by doing some R&D work, he came out with the idea that we can replace the steel bar with the date palm tree, because date palm tree is available in plenty in his own area, so he's replacing it. For that, he's doing some R&D work. After that, he came out with the solution of offering a glass fiber reinforced polymer woven rowing composite. Okay, this is the first claim he is telling, because it will increase the flexible strength of the reinforced concrete. And in the claim 2, it again elaborating that a reinforced concrete beam cast as claimed in claim 1, wherein the said date palm tree ratchet bar act as an reinforcement in a concrete flexible members, and the said bars are naturally seasoned, and the bars are cut and shaped as per the requirement. So it's elaborating. And in the third claim, is talking about wherein the said DPR bars are wrapped with the said glass fiber reinforced polymer composite using as an epoxy hardener mix to why he is using to increase the flexible strength of the said DRB bar. He is applying for a patent in this manner. This is the exact procedure how people will apply for a patent. He got an idea by seeing the bamboo. Instead of bamboo, is using date palm tree. Not only date palm tree, is using a glass fiber reinforced polymer. Why is using glass fiber reinforced polymer? Because it will increase the flexible strength of the said DRB. This is the actual solution for that. It's completely replacing the steel. Why is replacing? The cost of the steel is very high. Availability is problem. But here, this palm tree is available in nature. Cost is very low. Maintenance is very low. So everything is very low. So is easily replacing the steel bar into the palm tree. So problem, solution. And when he's offering a solution, he wants to protect the solution, so he's applying for a patent. And when you are applying for a patent, this is the way he is applying in the patent, and this is the exact procedure to apply in the patent. This is the exact procedure for claiming the invention. Okay. After that, finally, a patent certificate is granted to him. See, this is a patent certificate granted by Government of India with a patent number, application number, date of filing, and the inventor's name. These are all inventors. I told you, it is not necessary a single person to be an inventor. It may be a group of people combined to come out with a solution. Okay, and this is a title of the invention. Everything is in the patent certificate. Everything, all the details. This is the actual evidence, shows that he or they are the real inventors for this invention, because this document is given by the Government of India. Okay, so this is the procedure. When you are having an idea, it is created in the mind. Until it will be in the mind, there is no problem. And you are doing documentation. Documentation means you are preparing a document the same way he prepared the document. And publication. Before publication, you have to protect. Where to protect? You have to protect in the patent office, because it is related to invention. You have to protect by patent only, because patent is the only system, only tool available to protect your invention. Exclusive right. It gives exclusive right for a period of 20 years, and these are territorial rights. So he has properly protected his idea. This group of people knows that this is the method, and there is a system to protect an idea. They clearly used this IPR system, and they protected their idea. Hereafter, for 20 years from the date of filing. When is the date of filing? This is from 2002 onwards up to 20 years. These people are the actual inventor for that invention. Nobody in the world, nobody can misuse or use this invention without their consent. But these people can transfer this to another people by way of agreement, by way of assignment, by mutual understanding, by getting a monetary benefit. It is not necessary these people should execute that one. They have invented, they have secured it. Now they are free to sell it to anybody. The same way I am selling my land to someone, I am selling my house to someone. The same way now I am selling my ideas to someone. But when I am selling my ideas, before selling my ideas, I have to protect it. Then only there should be a legal remedy for that when I come to know that somebody is misusing my ideas. This is known as patent. Clear? Now you are coming into the next two, designs. People often misusing or misunderstanding the concept between patent and design. That is, people are using the word design patent. There is no word called design patent. Patent is different, design is different. Patent is purely technical and it is available to protect your ideas in the field of science and technology. But designs is in a broader sense, it can be used in any field. For example, these are all designs. Designs just for protecting a design idea, just to attract the customers. Aesthetic appearance, it will increase the aesthetic appearance. Just for example, if you see the doll is having different colors, and one hand is orange color, one hand is blue color. There is no logical in that, but it gives some attraction to the customer. So for the attraction purpose, we are using the design concept. You see the bottle also, different shapes, different textures are there, but the purpose is to hold the water. All are 1 liter bottle, but see the shapes and size, see the color. Instead of blue color, we can use the red color, green color, whatever may be, just to attract the customers. If you see the definition of this one, shape, features of shape, configuration, patterns, ornament, or composition of lines or color apply to any article, whether in 2-dimensional or 3-dimensional, or in both form, by any industrial process or means, manually, mechanically, chemically, which is in the finished article appeal and to a judge solely by the eyes. By seeing that article, I am get attracted. If you are buying a car, first we see the shape of the car, color of the car, designs of the car, then only we go into the technical matters. Most of the time we won't go into the technical matters, seating arrangement, how the seat shapes are there. When you are purchasing a furniture, we are seeing that colors, shape of the furniture, everything. These things are protected by designs. Okay, you see the next one is purely in a textile related designs. Many types of designs are there just to attract the customer. There is no technology involved in that. Just to attract the customers. This is related to textile. Shapes of the bottle. You see, different shapes of the bottles are there. Why? Inside the bottle, the shampoo are similar, deeply nourishing. Everywhere it is deeply nourishing. Everywhere it is Dove. But see the shape of the bottle, just to attract the customer. But in some cases, this having some technical advancement also. If you see the bigger one, the lengthy one, it is easy to handle. And the next to the bigger one is a bulky one, very short. What is the difference? We can say that this is for attraction purpose. Attraction purpose is good. It's the first major thing. Also, there is a stability problem. The bigger one having stability is low when comparing to the shorter one. This is one technical advancement also they are saying in that product. But actually telling this is just to attract the customer, they having different size and shapes in the product. You see the white with blue color. There is no combination. There is no relation between white and blue color. But it is attracting you. But just for attracting purpose, they are going for this. And the types of innovative ideas are protected by design protection. Okay. You see, this one is Orpik. Nowhere it is written as Orpik. But just by seeing the shape and color, we are identifying the product. So the design is playing a very vital role in the market to attract the customer, and also it will distinguish the product from one product to another product in the market. So design, R&D, people involved in R&D related to design is a huge market, because design is very, very important when we are buying a product. And this is Kolon. This is also having a special size, combination, colors and everything, just to attract the customer. Apart from many technical aspects are there, we are having a pump mechanism and other thing. This design is also very, very important. We cannot produce a product in a plain manner. Every product I will produce in a plain manner. That is not suitable, because each customer having different types of different tastes. So depends upon the different tastes, each people will select a different product. So in order to attract the customer, you have to concentrate more on the design aspect also. So design is mostly 50% non-technical in nature. So the main purpose of the design protection is to protect your design before it's coming into the market. Same thing, concept, documentation, and publication. Publication means bringing that product to the market. Before bringing the product into the market, you have to protect it. So how to protect it? To protect through designs. Because I cannot go for a patent, because patent is purely related to technology, and design is not non-technical in nature. It will give protection only to your aesthetic appearance. And third one is a trademark. This is a known thing, trademark. Why we are going for a trademark? When I want to sell a product in the market, when I want to open a company, I need a trademark. I need a name to protect, to distinguish the product, one product from other product. A trademark. These are all simple example for the trademark. A sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. So this is a distinguish. A tick mark, Adidas, Puma. M is a McDonald. By seeing the symbol, I am recognizing the company as well as the product, as well as the quality of the product. So that is the advantage of trademark. So nobody in the world can use this symbol for their own product. Adidas. Adidas means all over the world, nobody can make use of this symbol. Because when I'm talking about Adidas, immediately I'm thinking about the product and the quality of the product. Correct? FedEx is there, Blue Dart is there, Courier is there, India Post is there. These are all registered trademark. Nobody can use this trademark without the consent. Even with the consent also, they will not give to you, because trademark is particularly related to one company or one product. Why we are going for trademark means it will distinguish the goods or services from one company or one product from other product. Suppose if I want to open a company, a pizza, burger related to company or a hotel, I can keep any name, any symbol, but I cannot use this M symbol. Suppose I am using this M symbol, this McDonald people will put a case against me because I am misusing their own trademark without their consent. So that is the advantage of trademark. These are all some more examples for trademark. Coca-Cola is there, LG is there, Nike is there, L'Oreal is there. It may be a brand name, it may be a slogan, sometimes it may be a mark, sound mark also. So symbol, a coined word, or sound, or slogan, or brand name, whatever may be. It should be unique and it should distinguish your product or service or goods from the others. By seeing the trademark, you are identifying the product and identifying the company and identifying the quality of the product or quality of the service. That is the advantage of the trademark. Okay, how to indicate your trademark? So trademark application has been filed. If you see TM is there, if R is there, that means it is registered in the trademark company. So better not to use such a symbols or marks when you want to have your own trademark. So better go for a coined word or coined symbol or slogan, whatever may be, but don't copy. When you see the word TM is there, R is there, that means a trademark application has been filed and registered. It's already got registered. Okay. And finally, copyright. Copyright, you know very well, and these things are coming under copyrights. Literary works, paintings, photographs, diagrams, films, music, choreography, sculptures are coming under copyrights. See, there is a huge difference between copyright and patents. People often confuse with the word patent and trademark. People often come to us and ask, sir, I have an invention, I want to go for a copyright. Sir, I have written an article, I have written a story, I want to protect it through patents. There should not be any confusion between patent and copyright. Patent is purely technical in the field of science and technology, in any field, but it should be related to science and technology. And copyright is entirely different. It's a creative of idea. Literary works, I am writing a story, a creation. I'm making a painting, a creation, photograph, diagrams, and these are the coming under creativity and completely non-technical in nature, and this should be protected only by copyrights. So this is another tool to protect your ideas which is non-technical in nature. Okay, so a single product, I'm bringing a single product. Yeah, pressure cooker. How many IPRs are there? First one is patent rights. The construction features, the metal I'm selecting, the diameter, the thickness, the vessel arrangement, the pressure withstanding capacity of the cooker. These are all purely technical in nature, and each and every improvement related to technology are coming under patent rights. You have to go to the patent office for protecting your innovative ideas. To see the aesthetic appearance of the product, is a metal in black in color, some peculiar shapes they are giving, size they are giving, which is not going to play any role in the cooking process. Just to attract the customer, you are giving the color. And this aesthetic appearance should be protected by design. So you have to go to design office. And name of the product, premium. When I'm saying premium, immediately my mind will go to the product and company as well as quality of the product. So these are coming under trademark. And if you want to produce a product, you want to sell it in the market, you cannot use the name Premier, because Premier is already a registered trademark. It may be a name or logo. And catalog and booklet, you have in a catalog and booklet will be there in the product, is coming under copyright. If you see any catalog, they will put a C and a circle. That means it is copyrighted. Nobody can use the same type of thing in their own product. Okay. And finally, a geographical indication. Geographical indication means it is also a part of intellectual property rights, but an individual person will not get a geographical indication. When a group of people can apply for a geographical indication, it will be given to the group of people in that particular area. For example, some of the product having a special quality because they are originated from a specific places. For example, Kanjipuram saree. You cannot manufacture Kanjipuram sarees in any places. You can manufacture this Kanjipuram saree. You can get the Kanjipuram saree in anywhere. But manufacturing of this Kanjipuram saree can be taken place only in the Kanjipuram by a particular community of people, because they having their own technology, own methodology, and raw materials available for manufacturing this thing is available only in the Kanjipuram. So the people who are involved in that manufacturing of this, producing this Kanjipuram saree will get this GI tag. We say as GI tag, geographical indication. Why we are telling this geographical indication? Because that product is originating from a particular place, they are having a special quality. If you see, this is Mysore silk. Mysore silk is available in all over the world or all over the India, but it can be manufactured only in Mysore silk, because this is another GI tag. Why they are going for GI tag? The GI tag telling the quality of the product. When you are selling a product for 10 rupees, after getting the GI tag, you can sell it the same product for 50 rupees, because GI shows the originality, quality, and it is originated in a particular place. Madurai Sungudi saree is another example for GI, and these are all some of the GI product. Just for observation, you can see that geographic indication sign used on product that have a specific geographical origin and possess qualities or a reputation that are due to that origin. Because of that origin, it possesses a quality or a reputation. Many GI product are there. If in a website you can check many type of GI product is available, and now people are showing more interest to get this GI tag, because it will increase the quality of the product, and also it will increase the price of the product. So quiz, I am having some quiz. Madam, can you answer for that, or I will?
Yes, sir, we can pose the quiz.
Yes. Find the IP. The first one. So we have different types of IP: patents, designs,
Copyright.
Copyright, because it is a
Picture.
Second one.
It's a statue. Copyright we can use for this.
Yes, copyright because it is a sculpture.
Creative, yeah.
Third one,
Third one,
symbol,
created, yeah, symbol is trademark.
trademark, distillery,
Trademark.
Coca-Cola.
Coca-Cola also, I think we can go for trademark.
Yes, yes. Which type of IT protect the painting painted by the artist?
Uh, Anyone in the participants would like to answer the question? Anybody in the participants would like to answer this question? Sir, copyright?
Because it is a painting.
Yeah. Designs?
Designs, because of it's a fashion designer. Okay, it's a designs.
Yes. Patent?
Because it is related to a technology.
Yes.
Okay,
Pathani sari?
Paithani sari,
Uh, Geographical indication. Pathani sari should.
because it is originated from a particular place.
Yes. Trade logos, names,
Logos,
and
names, and brands.
Name and brand.
Very good.
20 years.
20 years.
20 years.
20 years.
Copyright.
Copyright.
Copyright, because
Copyright.
yes,
Copyright.
you are writing a story and it can be protected by copyright.
Registered design.
What do you do? You want to show your clothes are made by his company.
GI.
No. Cricketer, it's a single person. GA is for a group of people. He's a single person. He has started a company.
Patent.
registered
Trademark.
Trademark. Because he want to show the difference between his company product with other company. So he should have a trademark. He can go for a design also. But here the question is how he distinguishing his product from other product. Then it is a trademark. Patents they cannot go because there is no involvement of any technology. Copyright means arts related to arts. Geographical indication, a group of people. Patents related to technology. Registered design is non-technical in nature, just to attract the customer. And trademark is used to show that this product is owned by a particular company. Clear?
patents.
Patents, because it is involved in technology.
Technology.
They are developing a new technology, so they have to go for a patents. Thank you. If you have any doubt, you'll ask me.
Thank you, sir.
And if you have any
Dear
doubt, you ask me.
participants, yeah, the session is open for question and answer. You can either post it on the chat box or unmute yourself. Any questions from the participants? Thank you so much, sir, for sharing such valuable knowledge with us. It was truly an enriching experience. As we conclude today's session, it is time to express our heartfelt gratitude. For that, now I invite Mr. KVR Prasad, Associate Professor, Department of Civil Engineering, to give vote of thanks.
Good afternoon to one and all. I, KVR Prasad, Associate Professor, Department of Civil Engineering, deem it as my privilege and honor to present the vote of thanks today. First of all, I would like to thank our today's resource person, Mr. Uday Shankar, for his very nice explanation and presentation which he has presented today for us. Sir, you have covered the various topics, including the various stages in the innovation and invention, also formation of the concepts or ideas in the mind, documentation, publication, all these elements, you have explained it. I think all the participants will agree with me and they will join with me in appreciation of yours. And thank you very much for taking your time and presenting very good lecture today, sir. From the Department of Civil Engineering and Saram VIT fraternity, I thank yourself from the bottom of my heart. I thank you very much, sir.
Thank you, sir. Thank you.
Thank you, sir. I take this opportunity to thank our management, Sri Krishnadevara Educational Trust, who supports us in all these activities, and also especially our principal, Professor Rakesh SG, who is always behind us, who motivates, supports, and guides us in the conduction of all these programs. I take this opportunity to thank our head of the department, Dr. Ravikumar H, who is always there in the preparation of time schedule and contacting the resource persons, along with another coordinator, Mrs. Anita J, for the successful conduction of this program. I take this opportunity to thank all the faculty who helped us in the successful conduction of this program. Last but not the least, I want to thank the various participants who have joined from all over India to attend this program. I also thank the media publicity team of Saram VIT who has done the live streaming of this program. So, thank you one and all. Thank you.
Thank you, sir. Thank you so much for joining us. It was really a very informative session for all of us, and I'm sure our participants have hugely benefited from the same. Dear participants, the feedback link is being posted in the chat box. You can all take time and fill it. Thank you, sir.
Thank you, madam. Thank you.